Nevis LLC Part 3. Here are some of the advantages of a Nevis LLC, and I'll go ahead and list them now. First of all, a Nevis LLC is exempt from taxes in Nevis. Inexpensive initial formation and annual maintenance. It can be established within 24 hours. It can operate a business in the U.S. or other jurisdiction. It does not require paid-up capital. The company is protected from seizure by a judgment creditor. The assets inside the company are protected from a judgment against a member. Single-member LLCs are legal. Single-member LLCs receive the same asset protection as multi-member LLCs, and that's not the case in most U.S. jurisdictions. Members or owners and managers, those who run the company, are not filed in the public records. A manager of the LLC can control the company 100%, and a manager is not required to be an owner, yet can control 100% of the company and its assets. A person or legal entity from any country can be a manager of a Nevis LLC. There are not any foreign exchange controls. You can manage an LLC from any other jurisdiction, and a U.S. corporation or LLC can convert to becoming a Nevis LLC. So in other words, if you have a company in California, New York, Florida, or other place, you can take that LLC and turn it into a Nevis LLC. Now on the taxation issue, I must say it's important to follow the taxes of the jurisdiction in which you reside. Now, LLC legislation. The LLC statutes are created and the LLCs are filed under the Nevis Limited Liability Company Ordinance of 1995 and as amended in 2015. The statutes were originally based on the company statutes in the very favorable U.S. state of Delaware. The Nevis Limited Liability Company Amendment Ordinance of 2015, or the ordinance, was enacted on July 1st, 2015, and there were two major asset protection revisions. First, there was a restatement of the section dealing with charging orders. Second, there was a new section added regarding fraudulent transfers. The main change to the charging order section is that the charging order is the sole remedy that is available to any judgment creditor, including a bankruptcy trustee. That is, whether the Nevis LLC has only one or multiple members, Nevis courts will not allow seizure of the LLC or the assets held therein. Moreover, the charging order is not allowed to include amounts that arise from fines, penalties, or punitive damages. The charging order against a Nevis LLC is not considered a lien on that member's interest in the company. The one who has the charging order may not jump in and become a member, so the original owner retains his ownership. They cannot exercise the rights of any member, and the holder of the order cannot interfere with any management decisions. They cannot liquidate or seize the assets of the company, and they cannot restrict the company's activities. They also cannot dissolve the entity. So unlike a U.S. judgment that typically lasts 10 years with a 10-year renewal for a total of 20 years, a Nevis charging order is not renewable and has to expire after 3 years after it is filed. Moreover, the company can continue to seek additional investments from its members and can hold on to the distributions that would normally go to the charged member. In Section 43A, a new statement was added dealing with fraudulent transfers into the company. This section addresses creditors who try to seize assets that a judgment debtor has transferred into the company. Taking after the Nevis and Cook Islands law having to do with trusts, this section says that a creditor needs to prove beyond a reasonable doubt that the reason for the transfer was to defraud that particular creditor and the member thereby was made insolvent. Moreover, the calculation includes the entire fair market value of the member's interest in the LLC. So if the fair market value of the member's assets were greater than the amount of the creditor's claim when the transfer was made, the courts do not consider the transfer to have been made with fraudulent intent. In summary, unless the client says, yes, I put my assets in the Nevis LLC to keep them away from you, Mr. Creditor, and give some other legitimate reason for moving the funds into the LLC, the reasonable doubt statute should suffice to prevent a charging order against the Nevis LLC, even if it was done in a short amount of time. Even if a creditor receives a charging order against the LLC, the statutes make it virtually impossible to obtain the company assets. So the sooner one puts assets into a Nevis LLC, the better. The reason is because of the 2-year statute of limitations on fraudulent transfer for a creditor to even be able to file a claim against the member's interest in Nevis. Even more painful for the one filing the lawsuit, a creditor is required to post a $100,000 cash bond up front with the courts before filing. So the Nevis LLC statutes are riddled with multiple barriers to prevent the creditor from getting at the member's assets.